Jeff Meyer, thank you so much for rejoining the rebooted DOA podcast. You know, I love to have you on about legal and political issues. And though the column wasn't as popular as I thought it might be, I still say when the state of Illinois creates a law that essentially makes folks who engage in drunken sex both rapist and victim, you got to start looking out for that kind of nanny statism.
So, I don't disagree.
Okay. Well, again, thank you for joining me. The background. What started this whole process is, at the time, Northwestern freshman Kaylin on AHN, and I normally wouldn't identify a purported rape victim, nor would many journalists, but she has made this her cause, and her name is out there. Was talking to a male friend. He's going to come pick her up to go to a party. Picked her up in Skokie. And they never made it to the party because they had sex in the back of his car. Now, she claims she was pretty inebriated, in her own words, at the time and could not consent. She never said he forced himself on her. She never said anything of the like. She just claimed that she was too drunk to consent and he should have known it. Fast forward, she lets it go for... you know what? My book editor hates it when I go fast forward. Moving forward, she keeps quiet about it for a few months, decides she was raped, goes to the Skokie police because this took place in Skokie, and they essentially say, Kaylin, the law provides for us filing charges if the person who assaulted you administered the intoxicating agent. However, you were voluntarily intoxicated. Those cases are very difficult to prove. Most prosecutors wouldn't touch it, so we're not going to pursue it. So Miss An, coincidentally, had worked for Arlington Heights State Rep Mark Walker for a summer or so, and she went back to his office and said, look, we need to close this loophole. And of course, give a progressive Democrat a cause. Miss An is an Asian woman, a minority. And so he ran with it, created an amendment to the existing law. And for folks who are interested in the exact wording, I would encourage them to go to thefirstword.net, where I've included it. Amended the existing law to essentially say you cannot consent to sex when you're intoxicated. And the ramifications of that, I still will never forget our discussion on it. What I did not include in the column is my 30-minute talk with State Rep Walker's aide. It was a fascinating debate. He said some things that we will bring up here. But basically, as he started losing the debate, his defense was essentially, once again, to call me a scurrilous cad. And whether I am or not isn't the issue. I did ask State Rep Walker to appear on the podcast with you and I, but he chickened out within 2 hours because apparently, they don't have to talk to their constituents, and the entire state is their constituents, particularly when they disagree with them. So the first problem with this amended statute is it does not define what intoxicated is.
That is true. Before we get to that, Jeff, sure. I want to, if we can, maybe give a distinction or give the listeners a distinction between what this amendment actually affects versus what it doesn't. Because some people think, oh, wait a minute, there have been other cases. Remember, it was, I think, out west somewhere, there was the young lady who was unconscious in the yard of somewhere on a college campus, and there were some young men that then forcibly raped her, and that was a noteworthy case, I think, for what happened with the judge, as I recall, or what the judge's comments were, or something of that nature. And he got a light sentence. People thought that was egregious, and I agreed. But that's not what we're talking about here. This isn't a circumstance where there was clearly no consent because someone was unconscious. We're talking about a statute that addresses a particular subset of unconscious victim or a victim who doesn't perceive what's happening. And that's one where the perpetrator believes or there's some enunciation from the victim that that there is consent being given, but in fact, even though someone is quote unquote saying yes, they're not able to actually give knowing consent. They're not able to say yes because they are intoxicated and don't understand what it is to say yes. That's what we're talking. We're not talking about the young lady in the yard. We're talking about circumstances where there's a, hey, do you want to? And someone says, yeah, why not? But now the law is saying,
or kind of goes along with it. Yes.
Imply or express kind of consent. We're talking now about circumstances where even though there's some implied or expressed quote unquote consent, the person giving it can't actually give it.
Correct. And the law, the existing law already dealt with the fact that you can't, an unconscious person cannot provide consent. So that was in the law prior to it being amended. What this law, again, what this amendment does is essentially say, you can't, somebody who's, quote, intoxicated, nobody can see my air quotes, cannot give consent. But the kick in the butt from the very first time is you and I, when we talked about this, and I joked about this in the column. Okay, so you head out to Firefox here in Geneva. It's the third date. You're having a great time. You each have a couple Jamesons, and you go back to her house. Things are getting hot and heavy. What's the guy supposed to do? Pull out a breathalyzer and say, here, honey, I need you to blow into this. But even if he did that, because the statute doesn't define what intoxicated is. I mean, we know, Jeff, regardless of our size, regardless of our capacity to handle alcohol, if we get stopped by Kane County's finest in the western reaches of Kane County and we blow a .08, we're going to get charged. But in this case, they don't define intoxicated.
Here's what the law says expressly. And I'm going to cut sections out so it makes a readable sentence. Okay. Sure. But unable to give knowing consent also includes when the victim has taken an intoxicating substance or any controlled substance. So that's alcohol, marijuana being intoxicating, or controlled being some other drug.
Heroin. Right? I mean, you name it. Yes.
Yeah, you name it. And they can, causing the victim to become unconscious of the nature of the act. And now we define unconscious of the nature of the act. It includes, number 2, was not aware, knowing, perceiving, or cognizant that the act occurred. So it doesn't provide, as you point out, any level of intoxication, just as you've taken an intoxicating substance. So you drank, right, and you're now no longer, quote, aware, knowing, perceiving, or cognizant that the act has occurred. Really hard to crawl into the mind of the other person and know exactly what the level of cognization really is. And there's no bright line. It's going to lead to a circumstance where you've got a lot of second guessing kind of after the fact. And, I say I wasn't, and how does that guy really know? And it does provide that you're known or reasonably should have known. That's a really tough line, especially
if the guy is just as intoxicated as she is. Oh,
absolutely.
And again, I mean, I asked Austin, I never learned his last name, Mark Walker's aide. I go, guys, you made a law. You wrote a law that doesn't define what intoxicated is. I mean, that's insane. And just, we did that because we didn't want to hamstring prosecutors. And you, when I told you that, you issued a line that I have stolen again and again. But I want to give you credit. What did you tell me, Jeff?
No, you go ahead.
Well, you said, so when do progressive legislators start working with prosecutors? It's funny how it worked out that time. So we've got a situation. I mean, it rises to a level of insanity because not only does it not define the term intoxicated, so now it's up to a judge or a jury. And I got to tell you, if I'm going to put, I'm not going to put my hands, I'm not going to put the definition of intoxicated when the statute doesn't begin to apply one in the hands of 12 people who couldn't get out of jury duty. So now you're hoping for a good judge. But even wackier than that, in the Illinois General Assembly's, pursuit of everything woke, their pursuit of being the most self-righteous progressive they can be, they didn't limit the genders here. They didn't define, they didn't say well, let's just say the entire statute doesn't mention gender. So you got two people.
So it's a race to the police department.
Exactly. You head out to a bar. You both were a little drunk before you got there. Now you're really toasted. And you have sex and you both wake up in the morning and you regret it. Whoever goes to the police department first can have the other one branded as a rapist. Now, I think police departments might laugh the male out of the precinct, for lack of a better term, but it's still a possibility. And as I said in the column, Illinois is the state where bad ideas go to flourish and anything that can happen does.
Yeah, I think with the legislators maybe thought they were just closing a loophole, because the distinction in the statute I just read to you is that beforehand, if you gave the intoxicating substance to your victim, then you couldn't, then they were deemed unconscious, basically, because you got them drunk. You forced them to be drunk so that they couldn't consent. Now we have a circumstance where I don't know how much they drank, who gave them what. I wasn't the guy who did that or the gal who did that to the other person. And so it makes it really hard to know or reasonably know how intoxicated they are if you're not the one who gave it to them. I guess if you're sitting at the bar with them and you each slam down 10, maybe you have a little bit of knowledge then, but this is far broader than that. It's literally a person could have been pre-gamed before going to the bar. You don't know what else they took before they came. But now we're arguing about what you should have known versus what you actually did know. Nobody, you nor I nor any other reasonable person is condoning forcible rape. We're not condoning date rape or anything of that nature. Those are all clearly illegal and should be illegal. What we're facing, though, here is a statute that now has been amended to really start to criminalize what is far more of a gray area when it comes to consent or lack thereof. We rightfully teach people that no means no, and it does mean no. But now yes can mean no based on what 12 people after the fact or a judge after the fact, months or years later down the road, now deems what you reasonably should have or should not have known when you were out at the bar, drinking with your date or your girlfriend. It is, I think, maybe a well-intentioned but still an overreach that now is going to criminalize what is probably not altogether an infrequent occurrence for especially young adults engaging in this kind of activity with you.
Well, I mean, I don't know if you want to go into it being the upstanding attorney you are, and I do count on you keeping me out of jail, though I will note I have not been arrested in over 4 years. But I mean, you kind of launched into a great description of your college days and the events that typically took place. Do you want to get into that here, or do we just want to leave it to the listener's imagination?
I'm a married man with a family now, but I mean, everybody, a lot of us go through, especially in our, college days, younger days, whatever. I mean, it wasn't altogether infrequent for, my peers to go out and meet people at bars. Okay. I what people do after go out drinking, young adults, that kind of thing happens. But the point I was making in our somewhat private conversation was that, look, I mean, there were times when I probably, and I'm sure that other people as well are similarly situated, we weren't as sharp as we otherwise would have been, but nobody was engaging in something that they knew the other person was not consenting to. Right. But now you're left second guessing, well, did I really perceive that, their level of intoxication or lack thereof? I was, somewhat intoxicated too. It's really hard to judge that after the fact. And, the law before didn't criminalize it if you weren't the one forcing the other person to be intoxicated, thereby lose their sense of consciousness. And now it does.
Well, and, you technically, Jeff, you're not a criminal lawyer. You've certainly done all right for me. But, calling on your years of legal experience, I've rattled this around in my head. And I keep thinking, well, if you've got any reasonable judge is going to make the victim, male or female, prove they were intoxicated. The burden of the proof is on the plaintiff. It's on the people. But then I wonder, are the way judges going to read this law? Are they going to be so afraid of aggravating the woke populace? And Illinois has got plenty of them, that they're going to have to make the attacker prove that she wasn't intoxicated? Which way do you think it's going to go?
Well, I mean, the law, if the judge is following the law, the law requires that the state prove every element of the crime beyond a reasonable doubt. And that would include proving beyond a reasonable doubt that the victim had taken an intoxicating substance or a controlled substance, and that was therefore unconscious of the act, as unconscious is defined. And there's 4 subsets of a definition for what unconsciousness is. And it doesn't just mean what you think it means, where they're literally blacked out. Unconsciousness can be as vague as, like I said, not aware, knowing, perceiving, or cognizant. That's pretty broad.
Yeah, but how do you think? So, I mean, will judges tend towards that, or will they kind of let a little progressive creep in?
I think it depends on the judge, Jeff.
Okay, that's kind of what I figured.
Depends on the judge.
And how does the victim, because again, it doesn't differentiate between male and female, prove they were intoxicated? Especially, in this case, in Miss Ann's case that fomented this shift, it was just her saying she was pretty inebriated. It was the male and her in the car alone. Well, how could she possibly prove it?
The statute doesn't require, and I think it's even worse in one regard than you think it is, because it doesn't require you prove that you were, quote, intoxicated. It requires that the state prove that the victim took an intoxicating or controlled substance in any amount. So bar receipt, video from the bar, something, a third party who says, yeah, I saw, Jane there at the bar with Jimmy, and Jane was drinking a Mai Tai, took the intoxicating substance. Doesn't say it has to be intoxicated. Took the intoxicating substance. Then you get to the after the comma part, rendering the person unconscious of the nature of the act. Now, how do you prove that? That is a question, okay, but not aware, knowing, perceiving, or cognizant. I don't know. Maybe that person comes back to their apartment after the fact at 3 a.m., stumbles in, talks to their roommate, and the roommate's like, "Where have you been?" I don't know. I was at an apartment. I don't really know where it was. Okay. How'd you get home? Well, I mean, I don't know. I got a ride. I got on the bus. I found the bus. I mean, okay. So now you've got a roommate testifying that, well, when Jane came home, Jane was a little spatially disoriented and didn't really know where she had come from, or exactly when she left there, or exactly how she got back. Now, is that blackout drunk? Probably closer. Maybe it's in between blackout drunk and just, buzzed. Okay. But now you have somebody who is not aware, knowing, or perceiving, and a third party testifying to it. So now we can prove with the video from the bar that Jane had a drink. So she took an intoxicating substance. And now we have a third party witness saying that Jane, some point thereafter, was not aware, knowing, perceiving, or cognizant of something. Mm-hmm. Have you now met your burden?
I don't think so, but I don't think we should even go there. You and I agreed to this right off the bat.
But now maybe you have, and it doesn't matter that Jimmy isn't the one who gave the drink to Jane. I mean,
it doesn't matter.
No one is, again, neither you or I are saying that rape shouldn't be treated like rape, that rapists shouldn't be charged as criminals and tried and prosecuted and go to jail when convicted. But it's not, these are not so black and white. But we have now expanded the universe of what can be deemed criminal, not just wrong, and I would say questionable or bad judgment, but now criminal.
I would say vastly expanded it.
Yes,
and I talked to a number of judges, as you might imagine. I didn't, whenever my brain, can't, distill whatever logic there's supposed to be in these regards. One of my female judge friends said, well, yeah, this is a little strange, but I think the fact that of what a sexual assault complainant has to go through will act as a deterrent. You got to go be interviewed by the police. You have to do the medical exam. Although, again, Miss An didn't come forward until 3 or 4 months after the fact. And then you have to go in front of a defense attorney who will likely tear you to shreds on the stand. Your thoughts on that, sir?
I'm sure that's always a disincentive to people coming forward and reporting crime, whether it be rape or any other crime. It's a gauntlet that you have to run through as a victim, no doubt about it. I'm sure that's always a disincentive to reporting crime, but people do report crimes. And if it is reported, again, you now have a circumstance where we've vastly expanded the definition of criminality. I agree with you on that, at least in this context. And we live in a time where those accused of these types of crimes, rightly or wrongly, face a tremendous, I think, a different kind of burden than they did before, notwithstanding the legal burden. I'm not saying that that's altogether wrong. Maybe it should be a circumstance where we tend to believe people more than not. But again, the law says that it's supposed to be the state proving the case beyond a reasonable doubt, that the defendant is not supposed to have to disprove their guilt. The state is supposed to prove their guilt. I don't know that with emotionally charged offenses like this, that's always the reality on the ground. And we now have a vastly expanded statute wherein somebody could find themselves having to more so defend themselves against an accusation than being proven guilty of an accusation.
And that makes sense. And while I certainly understand this judge's point of view, I've sat in family court, whether it was fixing my neighborhood or helping out folks with Judge John Dalton here in Kane County. And I have watched, and it's particularly the women, case after case after case, where the first thing the woman does, particularly if there are children and a custody battle involved, he physically abused me. That's the first thing they do. The second thing, about half of them do, is he abused my son, daughter, right down to sexual abuse. So yeah, I see it. When people get that angry at each other, it's particularly in the family law cases where they ostensibly once loved each other. Very, very strange things can happen. I mean, I recently read an article that on another topic that said, abuse claims on the part of women in family court are false abuse claims are non-existent. I immediately went to my family court friends who said, no, that's not the case. So that does bother me. It's just too easy now under this law. And I mean, going through a trial is never an easy thing, even if it's just a bench trial. But my God, talk about a way to get back at someone, male or female. The other thing that this law doesn't differentiate is whether you're married or not. So as I explained to my wife, and again, overall, it's not a laughing matter, but when the state of Illinois makes law this bad, we almost have to laugh at it. I warned my wife that if, I've had 2 or 3 glasses of wine, you better be careful. You better be nice to me, because it doesn't differentiate between married and unmarried people.
Well, there was a time, Jeff, when the law, at least in some places, in effect, said that you can't be raped by your spouse. Now, we know that's not the case. We know right. that's not the truth. And thankfully, the law has evolved over time to the point where that's now, very clear in statute that whether married or not, you can be a victim of rape from your spouse. Okay. But again, you're right. This statute is neutral in that regard. It doesn't differentiate between married or unmarried perpetrators and or victims. And so, yes, now, intoxicated spouses or, who now have had an irretrievable breakdown in their marriage and are in a divorce situation, and your statute hasn't run on something like this, it's possible that incentivizes or makes it easier for belated claims to be made in that kind of a setting. You certainly hope that people in a divorce don't, trump things up and little t trump things up. I won't deny that it probably does happen, but my friends and colleagues who practice in that area regale me with stories of what they perceive to be false claims from time to time.
Mm-hmm.
But a lot of times what happens too is that time makes you perceive something differently.
Absolutely.
And it's harder later on to disprove that something happened the way someone now says that it did in fact happen. And like I was alluding to before, these are the types of cases where sometimes the burden, even though it's not supposed to, gets flipped a little bit.
It does. And police departments who can already be prone to, you know what? We're just violent. We're going to let the state's attorney decide, and we're going to let the judge sort it out. In this case, I think they're going to be loath to apply their discretion, because the last thing they're going to want is the victim, most likely the female, to rage on social media about how the police wouldn't pursue charges.
Yeah, let the courts and prosecutors sort it out, right?
Right.
Yeah.
But the worst part about this law, and I appreciate your compliment on bringing the column on thefirstward.net, by the way, to this illogical conclusion. In most jurisdictions across this vast nation, and in every jurisdiction in Illinois, being intoxicated, drunk or high, is not a defense against a criminal charge. Your Honor, I was so drunk, I had no clue I smashed that window. Even if you fell into the window and broke it, doesn't matter. You're responsible. But now what the law has said is, but if the victim of a, purported alleged sexual assault is equally as drunk, she is not responsible for providing consent. And I'm hoping that because of, you can't have, I want to use the word dichotomy, but there's a better term for it. You can't have mutually exclusive theories in the law. So my fondest wish is that when the first time this goes to the Illinois Supreme Court, and it will, you and I know it's going to happen, that they'll strike this thing down and say, you know what, you can't say the male's responsible when he's crocked off his butt, but the female isn't.
I mean, it's certainly an ideologic inconsistency in the law.
That's the word I'm looking for.
Right. Right. I mean, voluntary intoxication is not a defense to the mens rea requirement of a criminal offense. That's right. Hornbook law from, my first year of law school. Okay. Everybody knows that. You can't say, well, I was drunk, so I didn't know that shooting the guy was a crime. You're going to go to jail. Okay. But yeah, you're right. On the one hand, we say it doesn't excuse the mens rea of the perpetrator, but now we're saying that it does negate the ability of the victim to otherwise consent to the act that they're engaging in. Even when they're the ones who got the alcohol or the other intoxicant, wasn't forced on them by the person who is accused of the rape. Totally voluntary on the part of the victim here, but they're now deemed to lack the ability to consent, even though they've expressed consent, and the other person really believes that hey, this is everyone's on board here. That's certainly an intellectual inconsistency, and it's not a circumstance where, I thought she said yes. Of course, she's blacked out, passed out, like literally unconscious and not responsive. Okay, no one's saying that's that. Well, she said yes, and then she was, blacked out, passed out, and totally unresponsive. So I thought she was still consenting. That's not what we're talking about.
Absolutely not.
That's subsection 1, where I don't have maybe I'd even be fine with the statute if they had, taken away the ability to consent when someone else gives you the alcohol and left it at when the victim is unconscious or asleep. Because come on, there's no way the person on the other side of this act would not reasonably know that this person can't possibly consent anymore. They're asleep or unconscious. But we have this amorphous and vague other subsection of not aware, knowing, perceiving, or cognizant. It's really hard to crawl inside the mind of the other person. Really hard to do that. especially if you yourself are you've been partaking in the libations throughout the evening as well. And to what extent they're not aware, knowing, perceiving, or cognizant. I mean, you ever had a little bit of alcohol, Jeff? I'm sure you have. I have. Okay, that's like a there's a slope there, right? Mm-hmm. At what point do you really are you not aware, knowing, perceiving, or cognizant? I mean, is it not at all? Is it a little bit not perceiving or cognizant? The statute doesn't define it.
And you bring up a great point, Jeff, because I mean, it's happened to me once in my life at Western Illinois, where I passed out after getting drunk, and it never happened again. I really didn't like it. And as my readers know, and my listeners are becoming aware of, I come from a long, long line of alcoholics, and I can drink with the best of them, but I have never been so drunk that I don't know what I'm doing. And isn't that part of the problem, though? I could probably finish off a bottle of Jameson's from now. It's 1:45 in the afternoon to 8:00 at night, and I'd be fine. I'd wake up the next morning a little dehydrated. I wouldn't go running, and I'd be fine. And I wouldn't drive, but I'd be fine. But there are some people, 2 Bloody Marys, and women tend to be lighter. They're not as physically big as men, for lack of a better. I was trying to do a judicious term. They don't weigh as much as men, so alcohol is going to have a greater effect on them, and that just gets into all sorts of, how do you prove he wasn't that crack? Well, I mean, guys don't get as drunk, and how do you prove she was? It gets even worse.
Here's the interesting thing, Jeff. Okay. Because you and I are having what I think is a reasoned conversation about maybe the unintended consequences of a well-intentioned statute. I mean, they were trying to close what they perceived as a loophole. I think they just did it very broadly. Okay. And I think it opens the doors to all the problems we're talking about. Here's a fascinating thing, though. The last House vote on this bill, I want to take a guess at what the vote was.
It went through without dissent.
Unanimous.
Yeah. It went through dissent with no dissent. Because nobody considered it.
And Senate.
Right. Nobody considered it beyond, I'm sure in many, well, first of all, the Democrats are going to go for it because, the nanny state. I mean, one of the things I think this law does, and I said this in the column, it demeans and diminishes women. It takes us back to the 1920s when women couldn't vote, couldn't smoke cigarettes, couldn't own property because men used that logic that they were too prone to emotion and they couldn't take care of themselves. That's what this law does. It says that women can't monitor their alcohol intake. Women can't be responsible for their actions. And it's a terrible notation. It's a terrible
This bill has to have had a terrible synopsis when it came up for a vote. I mean, because in the legislature the last few days, whatever. I mean, things just fly, right? Or even in the middle of the session, things just fly. So the synopsis must have been technical amendment, clarifying that whether you got it from the guy who is assaulting you or from a third party, when you're unconscious, you can't consent. Okay. Now, if that's the synopsis, I can see why everybody votes for it.
Right.
But the devil is in the details. And it's not just talking about literally unconscious where you're passed out, totally unresponsive. It's the slippery slope of, well, person said yes, I didn't make them drink anything. I didn't give them a roofie. I'm not a date rapist. Right. But I really did think that everybody was on board and everyone was voluntarily consenting to this. And now here I am a year later having to figure out, well, how drunk was I? How drunk was she? I didn't think she was, but now we're going to argue about whether my perception was reasonable. And the prosecutor is going to say, well, how many drinks did you have? So how did you really know that she was consenting? You really should have known she wasn't consenting because you clearly don't remember anything, but she's credible because, she's got a clear memory now of what happened. I think it was well-intentioned, but I don't think people really thought about it the way they needed to or to the level that they needed to.
No. And again, I mean, for our listeners' sake, I'm a classic liberal. Grew up in Evanston. I still believe people should be responsible for their actions. And this law removes too much of the responsibility. I understand.
And that was the point you were trying to make, Jeff.
Yeah.
And I'm sorry that I shifted gears on you. The point you were trying to make is that, we rightfully don't live in a society where we don't believe people are incapable of taking responsibility for making decisions for themselves. But here we've now got an amendment to a statute that seems to, say, hey, maybe you can't.
Exactly. And, there is one of the judges I talked to brought up the double standard. When men get drunk, they pat each other on the back the next day. Oh, I really tied one on. When women get sloppy drunk, they're kind of looked down on as almost slutty. I don't understand the double standard, but there are realities in this existence, and our woke General Assembly can't legislate them away. And one is that men are stronger than women in general. And I went to all the attorneys and all the judges
Jeff,
I knew.
I'm not a biologist, so I don't know if I can define that.
But I did go to all the judges and attorneys that I spoke to with daughters and said, what have you told your daughters? Some of them were college age, high school age, and the end of middle school age. And unanimously, they said, don't, watch what you drink. Don't drink with people you don't know. Bad things can happen if you get too drunk. And that's the reality. I tried to argue with Representative Walker's office, but the more I brought these points up, especially the dichotomy, the mutually exclusive legal theories about who's responsible for being drunk or not being drunk, and the more I won that argument, the more Austin resorted to that kind of progressive name calling. Back to the scoreless cat thing that I don't know what I'm talking about.
Tolerant is the tolerant left.
Yeah, exactly. And they can't perceive of someone logically thinking they're wrong. But so are we going to go, if we extrapolate this out to its illogical conclusion, and this is one of my favorite analogies, do the Bulls now have to make allowances for me to play center so that the first time I run up against LeBron James, I don't get put in traction for 6 months? How far are we going to go with this making accommodations for, quote, weaker people? It can get nuts. When I brought that up to Austin,
you can't put people in baskets because you can't presume that the person is in a basket. You have to allow them to decide whether they're in the basket, Jeff.
Well, explain that.
The argument you're making is that, and this is a problem with the left's theories on some of this agenda, is, men are stronger than women. Women are less capable of making decisions or whatever. But then at the same time, they say we can't put people in gender baskets, for example. That's my point.
Okay, I see what you're saying. And that's what this law does, too. Because, again, it doesn't differentiate gender at all.
Not expressly, but.
So what are your thoughts on my thoughts that the first time a case like this goes before the Illinois Supreme Court, and we both know it's going to happen, that they're going to declare the law unconstitutional based on one person can be held responsible for being drunk and the other person can't?
I think that's a tough basis to challenge the statute. This is well within the purview of things that the legislature has constitutional authority to legislate on. It's a health, safety, welfare, morals, criminal. The legislature clearly can pass laws about this stuff. There is a bit of a double standard, I guess. So maybe you're arguing kind of like an equal protection thing, but I don't think that's how this gets analyzed. I think it gets analyzed based on its language. Is the language clear? Is it within the parameters of what the legislature can legislate on? And I think it is. Maybe you can argue there's a vagueness problem. Because one thing laws have to do is they have to reasonably inform society as to what conduct is, in fact, unlawful. And you've got a very broad standard of not aware, knowing, perceiving, or cognizant. Okay. So maybe that's a basis to challenge it. However, that language itself, the aware, knowing, perceiving, or cognizant, has been in the statute a long time. It was in the prior version.
Correct.
That criminalize this when you do give when the perpetrator does give the intoxicant to the victim. So if that has withstood the test of time and there's been cases on it, I don't know. This probably stands facially.
Oh, Lord. Again, so Austin, again, Mark Walker's office repeatedly cited that we've talked to attorneys, judges, and appellate court judges who provided us with the language. And I said, oh, great. Send me the names of those judges. Send me what they said. Now, that was 2 weeks ago, and I still don't have it. But the way
I'm pretty sure, Jeff, that judges aren't supposed to be involved in the law writing process. I seem to remember that from civics.
I thought that was a strange claim.
Yeah. Pretty sure they're just supposed to interpret what the legislature gives them. They're not supposed to write it for the legislature, but maybe I'm wrong.
So, I didn't really know that. So if you approach an appellate court judge and say, what language do we need to use to make this work? They're supposed to say, whoa, can't do it.
Well, I this is more philosophic probably than what is written somewhere in terms of like an ethics rule, but we are supposed to have separate branches of the government. And I loathe the notion of courts writing law. Okay. The courts can speak in court decisions, and those court decisions can then guide lawmaking. And a lot of times courts do leave, Easter eggs out there about what language would suffice or would pass constitutional muster, on judicial review. But they're not supposed to actually write the statutes. They're not the legislators. That's why we have a legislature. Mm-hmm. The courts can tell the legislature, you got this wrong, this is unconstitutional, and give guidance in an official court action or in a decision as to what may pass muster. Okay. But I don't think they're supposed to be at the front end of that process. I have a real problem with the legislature getting into the judiciary getting into the executive and vice, supposed to be separate but co-equal branches of the government.
Yeah, although I have to tell you, I'm not so sure I believe Mr. Walker's office claim in that regard.
Well, that could be a thing too, because I think most judges probably agree with my philosophy on that than not. It's not to say that they never, as a body, the court never makes statements about public policy. I'm sure I've seen them and they do, but again, I don't think at the front end quite in that context. That's not their role. In fact, it's problematic if they play that.
No, I would agree. I mean, and my columnar theory, my summation, my end point was, if we're not careful about the nanny state that Illinois is becoming, and if COVID didn't make that apparent, nothing else will. And now we've got this law, and by the way, before I forget, I was going to say, isn't a law that criminalizes normal behavior a problem? A lot of people get drunk and have sex, married couple, it's just, it's what they do. And isn't a law that criminalizes generally normal behavior a problem?
Well, we're in a fluid area in this now, aren't we?
We are.
Yeah. So for 50 years, I guess what the response to that would have been is that there's some substantive due process 14th Amendment protection that would impede or prohibit the states from regulating this, even though facially they have authority. I mean, remember, Jeff, states are unlimited sovereigns. They have all authority unless they don't.
Right.
Okay. And that includes these are called police powers, the health, safety, welfare, morals. I mean, they can criminalize, you holding hand with your spouse. You can't hold hands with your spouse and walk down a sidewalk. They facially have the authority to do that unless there's something that says the people have not given that authority to them. They've reserved it in either state or the federal constitution as applied to the 14th Amendment. We're in kind of a fluid area now.
And that terrifies me. Yeah.
Well, I don't know if it terrifies me. I think it was a somewhat problematic area of jurisprudence, even setting aside the current contemporary argument and what the Dobbs decision does or doesn't do. It's always been problematic in the sense that it's not clearly defined. It was never clearly defined. It's not like you can look at the First Amendment and it says, okay, anti-establishment, free exercise, free speech, freedom of the press, right of assembly. Okay, boom, right there, 5 things, clear. As clear as you really can in a constitutional document. We know what it's talking about, but what is substantive due process?
Well, that sounds like a whole nother podcast.
Well, it could very well be. Okay,
Yeah.
But that's what you're alluding to,
right?
And so, now that you have to look both at the federal constitution its restrictions are now somewhat in flux in that area. And, that's, if you read the Thomas concurrence, he's clearly thinking that this has broader implications. I don't know that all of his colleagues are on board with him on that, and they haven't said so much yet. So,
and we're talking about the Roe v. Wade reversal, right?
Yeah.
Okay.
But it's not just talking about Roe. I mean, Roe was predicated upon 14th Amendment due process and what they one point called privacy, and the Casey court then clarified was really liberty under the substantive due process analysis. Illinois' Constitution has some protections standing alone from that, and the Illinois Constitution, of course, governs Illinois, and restricts its lawmakers, notwithstanding what the federal Constitution through the 14th Amendment may or may not do. So, I would hope that we as a society have said there are some boundaries constitutionally, at least under the Illinois Constitution, for what government can or can't do in these areas, what it can and cannot regulate. But you also hope, Jeff, and of course, this is a fleeting hope in Illinois, that just because they can doesn't mean they should or will.
Right.
Even if they can tell me I can't hold hands with my wife on the sidewalk, you certainly hope there's enough reasonable people serving in the legislature that they don't write that law, even if they can, because it's just bad policy.
I agree, and I appreciate the explanation. Again, but getting back to my final point.
Sorry, I went in the weeds there.
No, well, I understand, but you're an attorney. We all get it. I only play one on TV. But the bottom line is, like I said, I was surprised that this column wasn't as popular as like the recent one on Richard Irvin. But my theory is if the nanny state, the creep continues, and unless we Illinoisans wake up and see what's happening and fight back, it is only going to get worse. And you think the nanny state isn't going to come for you, but trust me, they will.
Yeah, well, here's what I don't understand is, on the one hand, the left gripes about, people being in other people's business. We shouldn't be in people's, bedrooms. We shouldn't be judging who they have relationships with, et cetera, et cetera. On the other hand, smoking cigarettes for those under 21 is criminal. Drunk sex now is criminal. Is there not some inconsistency in this that, on the one hand, we think that people should be able to do anything and everything, but on the other hand, we're going to micromanage how people live their lives.
If we start getting into the hypocrisy of the left and the right, and particularly progressives, I'm a man without a country, we will be here all day. And I know you have other things to do. Before we go, do you want to give yourself a plug and your law firm a plug, or would you rather not be associated with that?
Maybe we should just bury this one, Jeff. This will come out at a confirmation hearing someday, right? No, Jeff, always appreciate you having me on. It's been a while.
I love having you.
Glad the podcast is back. I always appreciate you soliciting at least my legal analysis on these questions. Jeff Meyer from Klein, Stoddard, Buck and Lewis in Sycamore, Illinois. Don't hold it against my partners if they let me hang out here.
Yeah, please don't. And again, I'm probably the only client in Illinois that's gotten 2 directed verdicts against the same entity, thanks to you. So if that isn't a plug, I don't know what else is.
No, I'm going out on top, Jeff. That's the end of my criminal defense career right there.
It's kind of like when I spelled Ypsilanti right in the column, I wanted to retire on the first shot. And Poughkeepsie. Ooh, I was going to Disneyland. All right, Jeff Meyer, thank you so much for joining me to discuss this, what to me is a fascinating topic. I hope other people find it equally as fascinating. We're going to get you back on, particularly after the primaries, to indulge our listeners in some political analysis. But again, thank you so much for hanging out with me today.